And with that, I will conclude panel 6 and give the floor to the Nuremberg Academy's esteemed director, Klaus Rachwitz, to make concluding remarks. Thank you.
Thank you very much, Jennifer, and hello, dear friends and colleagues in Nuremberg. I'm sitting at home with quite a big lump in my throat and a tear in my eye. I would love to be with you. Almost 3 years I protected myself thoroughly from the COVID virus, but now it hit me. And it hit me in a way that destroyed all my travel plans. Thank you all so much for a great conference with rich discussions on very important topics. The 20 years after the beginning of the ICC may be more relevant than ever. It was a pleasure listening to you, and there's nothing I can add on substance. How could I, given the wealth of experience and knowledge that I was privileged to visit or to watch over the last days. Well, let me start with some sentiments of my own, and I pick up a few things from the conference. As Luisa Campo really and rightly remembered us, Nuremberg was the starting point, the first time where perpetrators were not just executed by those who had defeated them, but brought before a court of law. And the individual guilt was established there, and immediately after the IMT has rendered its judgment, the General Assembly of the United Nations, who is rightly pointed that out, in its first meeting, affirmed the principles enshrined in the London Charter and the IMT judgment. That was a clear statement that this should be the future. No states guilty, but individuals are guilty, and their guilt should be established. And a year later, only a year later, 1947, the very newly founded International Law Commission was tasked to carve out those principles and make sure that they are in a text that everyone can read and understand without looking at the charter or the judgment. And the ILC duly delivered that text to the General Assembly in 1950. And that's the text of the 7 Nuremberg Principles, as we all know today, and which are the backbone of modern international criminal law. But what happened then in practice? Well, for almost 50 years, nothing happened. The euphoria of 1946 and 1947 was long evaporated. The block building had already started. The Korean War erupted a few weeks before the ILC presented the principles to the UNGA. Global justice was suddenly off the agenda. And horrible crimes were committed for decades in Asia, in Africa, in Latin America, and all over the world. In the Biafra conflict, the weapon of mass starvation was used for the very first time as a means of war, cost almost 2 million lives, many of them children. The Nuremberg Principles, not visible. Accountability, not existent. Fortunately, the international community came to its senses and created, almost 50 years after Nuremberg and Tokyo, international tribunals for Rwanda and the former Yugoslavia to adjudicate crimes mentioned in Principle 6 of the Nuremberg Principles and the Genocide Convention from 1948. And almost at the same time, the preparatory work started to establish a permanent international court. And we are in this forum now commemorating 20 years of operations of this very court, where the planning started in 1994. But that, in my view, does in no way mean a mission accomplished. On the contrary. I've been myself in an Assembly of States Party session where state representatives expressed, vis-à-vis in particular the civil society representatives, it's now good, it's enough, you have your court now, and all further requests for significant increase of resources do not find a supportive echo. This is so flawed, and it's flawed in more than one way. First, the ICC was not established to please the NGOs. It was established because impunity was the rule and accountability was the exception. And only in those cases where it pleased the majority of the Security Council members, in particular the P5 in the body. And that was no longer tolerable. Truth is, however, and Bill reminded us of that, it would not have been established, this court, without the pressure and perseverance from civil society. And the second flaw is the court was not established as an alibi, hence it needs the resources necessary to implement its mandate. And most importantly, it's not a sunshine court, only relevant and to be supported if there are no clouds in the sky, meaning there are no investigations against oneself. And insofar, the fact that states run away from the court in the very same moment when it transpires that situations in their own country may become ICC investigations situations, that's a telling situation. Which for me raises the question, how serious is the commitment of the states parties? How strong is the willingness to implement the Rome Statute and to implement impunity, in particular for the highest level of responsibility in a state, which is found in the head of a government? And there, the picture is not clear. Even 20 years later, 20 years of jurisprudence of the ICC. Many see it as a failure of the ICC that all attempts to triads of states did not yet, in my view, lead to a conviction. But in some cases, the practical questions of cooperation, evidence collection, witness intimidation, and others were at the forefront. In others, namely in the case of Omar al-Bashir, political and legal issues showed the difficulty of the task. Judge Ebro Yoshushi has us reminded in his presentation of the appeals proceedings regarding Jordan's non-compliance with its obligations under the Rome Statute. And I do not need to go into detail here again. He reminded us all that the ICC is not existing in a vacuum, but between many other provisions of international law, most notably, of course, the functional immunity of heads of state. And while state parties to the Rome Statute, by ratifying, accept that this customary principle should not apply to them, the question how this relates to non-state parties remains under discussion. We in Germany had even a discussion whether the functional immunity problem also applies to lower level perpetrators. But fortunately, and very clearly, the German Federal Court ruled that this is not a question, and of course, no impunity for functional representatives like officers of a foreign army. Julia Fernandez mentioned in her presentation that 123 state parties were not enough, and the court would still lack universal jurisdiction in its true sense. She is absolutely right. But a higher number of states parties alone is not necessarily a solution. The resolution on Russia in the United Nations General Assembly a few days ago had 143 positive votes. But the states either voting against or abstaining represent around 40% of the entire world population. And that dilemma will persist, and the ICC will, and has so far, have to cope with this. The hostile position of the United States imposing even sanctions on individuals of the court shows it very clearly. And in my view, a state acting like this has most likely something to hide. To hide from an institution that represents the rule of law more than any other international and treaty-based institution, in my view. And this alone, for me, creates a deterrent effect, albeit not one that prevents crimes at all times, and that has never happened with any deterrence. But we heard examples on how the mere existence of the court has changed behavior even in non-state parties. It took the court exactly 10 years after starting its operation until the first judgment was rendered. The case of Thomas Lubanga was the first one tried before the court, and it generated more legal and procedural questions than expected. In the absence of any guidance from previous cases, the Chamber, but also the parties and participants, had to overcome a number of complications and had to find answers to legal questions which did not arise before the ad hoc tribunals or in the courts in Nuremberg and Tokyo. This duration between the start and the first judgment has been widely criticized, and those who are opposing the court, for many reasons, jumped on the fact that the proceedings before the ICC would be lengthy, and as a result, the number of cases would remain relatively low. Well, the Nuremberg Academy, following a resolution of the German parliament titled Strengthening the International Criminal Court, in a research project jointly conducted with the Friedrich Alexander University in Erlangen, Nuremberg, has extensively researched the question whether the proceedings before the ICC are disproportionately long and whether recommendations can be made. And the research team has literally examined each day and each activity in all cases, which ended with a final judicial decision, be it a trial judgment, an appeals judgment, or a decision to terminate the proceedings. And the results of this analysis were inter alia compared with all the data from the ad hoc tribunals and form thus the most comprehensive study ever undertaken with regard to the length of proceedings before the ICC. And the main finding is that the proceedings, yes, they are lengthy. However, they are not disproportionately long because the cases are complex, the legal questions are manifold, and language and other practical obstacles simply cost their time. There will be a number of recommendations how one could accelerate the proceedings. And we will present this study during a side event at the Assembly of States Parties in December of this year. Our study will confirm that the court is facing many legal issues with borderline with political matters. And Judge Pangalangan reminded us of the judgment acquitting Bemba. This judgment has raised a lot of criticism. Even the prosecutor then published a press statement requesting the appeals chamber, and I quote, maintains the cautious approach to appellate review that it has always adopted in the commencement of its work, end of quote. Other comments saw it differently. For instance, Professor Heinze from Göttingen, should not in the interest of the accused an appeals chamber as the last resort apply a wide approach to the review of a judgment of a trial chamber? I would like to be very clear, I strongly disagree with the appeals chamber's finding in Bemba, and I think the acquittal was wrong. But this decision at least highlighted that command responsibility is not an easy way to a conviction. Judge Pangalangan in his presentation referred to the discussion in the Philippines, highlighting that it was, according to him, all about command responsibility and a way to nail the torture. And let me remind you that already the first defense lawyer appearing before the ICC in Lumanga, Maître Catherine Mabi, she cautioned very early against what she called a desire to convict. And avoiding this desire is what the appeals chamber did in Bemba, and I quote, the trial chamber must specifically identify what a commander should have done in concreto. Abstract findings about what a commander might theoretically have done are unhelpful and problematic, not least because they are very difficult to disprove, end of quote. In my humble opinion, the UTP had met this level of proofs and had demonstrated that Bemba indeed did not all he could do practically. But judgment is what counts and not my opinion. Many Germans in 1946 commented on the IMT trial that this was a farce, a mock trial, victor's justice, and far from being fair. I think it's prudent of the ICC to make very clear that the burden of proof is at a high level, in particular for cases of command responsibility. And it is command responsibility which is necessary to bring those to justice who sit on top of the pyramid. Neither al-Bashir nor Kenyatta nor any other head of state have pulled the trigger themselves. Thus, a court will only have credibility and acceptance if it avoids the quick trial and convictions based on perceptions rather than on proven facts. Insofar, the court must maintain high standards, even if it leads to unpopular decisions. In my view, acquittals by the ICC are not a failure. As many of you may know, I worked at the court in its very early days, initially as a member of the advance team and later as one of the two first staff members of the Office of the Prosecutor. And I stayed almost as long as Prosecutor Luis Moreno Ocampo's term lasted. And having had the experience of the very beginning, I would like to close my remarks with my wishes for the court's future. My present wishes, first wishes, and I feel myself in excellent company with Klaus and Carsten and many others, is that the ICC will be enabled to meaningfully adjudicate with what identified in Nuremberg as the main charge. In this very room where we all sit, physically or like me, virtually. The first crime in the Nuremberg Principles 6 lists is the crime against peace, and the principle defines it as, I quote, planning, preparation, initiation or waging of a war of aggression, or a war in violation of international treaties, agreements or assurances, end of quote. This remains the most important crime. Many call it the crime of the crimes, and it is this crime against peace nowadays, crime of aggression, where I see a great deficiency in the court's competence. The leaders of the Russian Foundation, in particular Russian President Vladimir Putin, ordered the brutal invasion of a sovereign country neighboring it, clearly a blatant violation of Article 2 of the UN Charter. This constitutes, in my view, the most serious act of aggression in the last 75 years. And it's exactly this aggression which Nuremberg Principle 6 mentions as the first crime and this position is not at random or a coincidence. It constitutes the most serious crime one can imagine, and as long as the ICC is not empowered to meaningfully investigate, prosecute, and adjudicate the crime of aggression, the court is not complete. I'm of course aware that already the Kampala compromise was difficult to achieve. I was in Kampala myself. But it is my firm view that the competence and jurisdiction of the ICC cannot end at the boundaries of Kampala. And more needs to be done, and the court's competence needs to be enhanced. Too many opt-outs, too many loopholes make the crime of aggression with all the present restrictions of Article 15 bis and 15 ter of the statute a weak tiger without teeth, which in my view is not having any deterrent effect on anyone who believes that brute force is legitimate and accountability for it is non-existent. Equally, the international community, in my view, must change the current system of veto powers in the Security Council. This is nothing that the court or the Assembly of States Parties can influence in any way, but it creates, in my view, a fundamental obstacle for the adjudication of core international crimes. I do not expect any of the P5 states to voluntarily surrender their veto rights. However, if already the suspension of veto rights in cases of core international crimes would be possible, a milestone would have been reached and situations like Yemen, Syria, and many others could come before the ICC. And this is my second hope for the ICC's future, that we will really move toward a meaningful universal jurisdiction. The invasion of the Ukraine and the wars on its territory started on 24 February, and many have referred to it. Already 2 days later, the prosecutor of the ICC was announcing an investigation. Subsequently, dozens of ICC states parties have stated that investigations have commenced under universal jurisdiction. To date, a joint investigation team comprising of 7 European states and the ICC jointly investigate crimes against humanity and war crimes allegations related to Ukraine. Never before in the history of mankind a judicial reaction to an act of war happened so timely. And this is clearly a game changer. This clearly shows the change in the landscape and in the mindset. After almost 50 years of complete impunity, investigations now start literally on the same time as the armed conflict itself. And this gives a lot of hope, also for the victims of war crimes and crimes against humanity. This encouraging signal would not be possible without the ICC and its work over the last 2 decades. And it should motivate us all to continue our efforts in the fight against impunity for core international crimes. Yes, there will be setbacks. Yes, there will be mistakes. Yes, there will be problems. And yes, it will take many, many years. But as I mentioned before, if we had given up after 25 years of impunity, we wouldn't have been where we are today. The biggest task that is, as I mentioned, the crime of aggression, and no veto should prohibit investigations and prosecutions. And in order to achieve that, our work is not finished. No, the work has just begun. I wish all those who are in Nuremberg physically a safe way home, and all on the screen a good weekend. It was an honor and a privilege to have all of you at the Nuremberg Academy. I would specifically like to thank all our panelists and the chairs who have blessed us with rich discussions, meaningful insights, and a lot of food for thought, which, and Klaus referred to it, might even be triggering activities of the Academy in the near future. And last but certainly not least, my warmest thanks go to the team of the International Nuremberg Principles Academy: Jennifer, Petra, Berthold, Evelyn, Alexander, Yolana, Mary, and Tainara, Bauke, Pablo, Emma, Annabella, Sarah, and Viviane, and to all our technical support team behind the cameras and behind the mixers who make this event happen. See you all again, I hope. Next time when I see you, it is going to be in person. Now, after my infection, I hope I'll be immune for a while. Thanks again for coming to Nuremberg. We all continue in the fight against impunity, whatever it takes, as Draghi said, and we will not give up. So thank you all very much, and see you again very soon. Thank you.